Hey everybody, welcome to another episode of Foreclosure Help 777, where we talk about everything foreclosure related. And guys, I try to help as many people as I can with foreclosure, and if you have a question, you can send me an email to foreclosurehelp777@gmail.com, and I'll try to help you answer your question. Okay, today we're going to talk about an important topic, and let's get started. Okay, so today we're going to talk about foreclosure affidavits and affirmations. And our Bible verse of the day is Matthew 5:37. Let what you say be simply yes or no. When a witness submits an affidavit or declaration, the court relies upon the truthfulness of that statement. Whether the witness swears on oath or affirms under penalty of perjury, the question remains the same. Is the testimony reliable, based on personal knowledge, and supported by properly authenticated records? So Matthew 5:33 through 37 says, "Again, you have heard that it is said to those of old, you shall not swear falsely, but shall perform to the Lord what you have sworn. But I say to you, do not take an oath at all. Let what you do say be simply yes or no. Anything more than that comes from evil." And that's true. And there's many affidavits and declarations out there. Let's go through some of these so you guys understand better. Is the bank's affidavit really an affidavit, and why this matters? Banks often rely on affidavits, declarations, business record certifications, and loan analyst testimony to obtain a summary judgment, order of reference, foreclosure judgments, admission of payment histories, and loan records. If the supporting witness statement is defective, the evidence may be vulnerable to objection. An affidavit versus a declaration versus an acknowledgement affidavit, guys. You need to know the differences. Must generally be sworn under oath, be signed by the affiant, and include a jurat. Look for language such as subscribed and sworn before me, or being first duly sworn. A declaration may be valid without a notary if allowed by statute. Look for I declare under penalty of perjury, or I affirm under penalties of perjury. Okay, let's look at one of these so you can see here. Here is an example of an affidavit missing the sworn part. It is just signed under a notary, as you can see right here. Good old PHH Mortgage and Richard Schweiner. It's just notarized. It does not have the sworn part. Okay, and here's one that is. See this one where the same guy is signing it, but this time he has right here where it says, "I affirm this 26th day of February 2024 under the penalties of perjury under the laws of New York that the foregoing is true, and I understand that this document may be filed in an action or proceeding in the court of law." So the first one wasn't done right, obviously, because it's missing that. So that's something to keep in mind when you're looking at these affidavits. Look for defects in what they're submitting. An acknowledgement is not the same thing as an oath. Look for personally appeared before me, acknowledged executing this instrument. The three things every homeowner should check. Check number 1, was it sworn? Ask, where is the oath? Look for the sworn, duly sworn, penalty of perjury, or jurat. If all you find is acknowledgement, that may be an issue. Check number 2. Does the witness explain their knowledge? Look for, I am familiar with the records. I reviewed the records. I am responsible for maintaining the records. If not, ask, how does this person know any of this? Check number 3. Did they lay a business records foundation? Look for language such as records made at or near the time, kept in the ordinary course of business, regular practice of the business, incorporated records from prior servicers. Without this foundation, many statements may be hearsay. The boarding problem. This is one of the biggest foreclosure issues. Ask, Did the witness explain how records from the prior servicer became reliable records of the current servicer? Many affidavits skip this step entirely. Common objections: lack of personal knowledge, hearsay, improper authentication, defective affidavit, no business record foundation, failure to establish boarding processes, conclusory statements. Common uses for homeowners' affidavits: payment history disputes. A homeowner can testify in their affidavit when payments were made, when payments were returned, when a servicer refused payments, when a modification was approved. Example: on March 3rd, 2024, I mailed a payment in the amount of $1,250. A true and correct copy of the canceled check is attached here as Exhibit A. And then you have your RESPA and QWR claims. The homeowner can authenticate QWR letters, notices of error, certified mail receipts, return receipts. Here's an example. Attached as Exhibit B is a true and correct copy of the qualified written request I mailed on April 5th, 2025. Loan modification issues. The homeowner can testify. Documents were submitted, calls were made, approval letters were received, contradictory instructions were given. Foreclosure notice defects. The homeowner can testify. Notice was never received. Notice arrived late. Notice contained errors. Now, courts may still require additional evidence, but the affidavit creates evidence in the record. And then let's talk about injunctions and TROs. This is where affidavits become extremely important. Many TRO motions are supported by verified complaints, affidavits, declarations under the penalty of perjury. Without sworn facts, the court may have little evidentiary basis to grant emergency relief. So the key limitation is an affidavit is evidence only of the facts the witness personally knows. It's not legal conclusions, not speculation, not internet research, not what someone else allegedly said unless filing an exception. Instead, it's what the affiant saw, what the affiant received, what the affiant mailed, what the affiant paid, what the affiant experienced. Let's compare a bad affidavit. The bank lacked standing and committed fraud. That's mostly legal conclusions. A good affidavit would say, the assignment attached as Exhibit C was recorded June 1st, 2024. The notice of default attached as Exhibit D was mailed April 1st, 2024, 61 days before the assignment was recorded. Now, the judge has actual facts to work with. Myth, every affidavit or declaration must be notarized. Not necessarily. There are generally three different things people encounter. An affidavit, typically signed by the affiant, sworn under oath, notarized with a jurat. Example, subscribed and sworn before me. A declaration under penalty of perjury is often signed by the declarant. Contains statutory penalty of perjury language, may not require a notary at all. Example, I declare under the penalty of perjury that the foregoing is true and correct. Acknowledgements typically are signed before a notary. Identity is verified, no oath is administered. Example, personally appeared before me. The question is not, is there a notary? Many homeowners look for a notary stamp and stop there. Instead, ask, was the witness sworn? Was the statement made under penalty of perjury? Is it merely an acknowledgement? Does it comply with the applicable state and federal rule? Does it establish personal knowledge and business record foundation? Some practical examples here. As you can see with this little table, an affidavit is usually notarized. It is under oath and penalty of perjury sometimes. A declaration is usually not notarized. It is not under oath, but it is signed under penalty of perjury. An acknowledgement is notarized. It is not necessarily under oath, and it is not under penalty of perjury. A notary stamp alone does not automatically make a document an affidavit, and the absence of a notary does not automatically make a declaration invalid. Red flags that warrant closer examination. Not every red flag proves fraud, but they tell you where to dig deeper. Red flag number 1, acknowledgement versus oath. As we've discussed, was it sworn? Was it merely acknowledged? Is it a declaration under penalty of perjury? Many people never look past the notary seal. Red flag number 2, out-of-state execution. Questions to ask. The property is in Pennsylvania, but the signer is in Texas? Or the property in Virginia is a signer in Florida? Property in New York, the signer in California? Large servicers often centralize document execution. That doesn't make the document invalid, but it raises questions such as, who actually reviewed the file? Where are the underlying records? And does the signer have personal knowledge? Red flag number 3, attorney-in-fact signatures. Ask, is the power of attorney attached? Was it effective on the execution date? Does it authorize this specific act? Was it recorded, if required? Red flag number 4, same signer appearing everywhere. This is a classic one. People start noticing, why is Linda Green signing for 20 different lenders? Besides Linda Green, the fact that someone signs many documents is not proof of robo-signing. However, the real questions are, did they review the records? Did they have authority? Did they actually sign? Did they understand what they signed? And red flag number 5, notary issues by itself. And this is also a big category by itself. Look for missing notary seal, expired commission, missing country, missing state, ineligible signature, altered dates, different ink colors, notary date inconsistent with execution date. Red flag number 6, impossible volumes. This is where robo-signing allegations historically arose. For example, one person signing hundreds of affidavits daily, one person acting as vice president for multiple unrelated entities, testifying to records they could not reasonably have reviewed. Courts and investigators paid a lot of attention to this during the foreclosure crisis. Red flag number 7, capacity changes. One document says vice president, another says assistant secretary, another says authorized signer, but it's the same individual. Ask, who appointed them and under what authority? Red flag number 8, dates that don't make sense. For example, assignment executed after foreclosure started, assignment recorded years later, affidavit referencing records not yet created, endorsement appearing after litigation began. Timeline analysis often reveals more than the document itself. Red flag number 9, missing foundation. This applies to servicer records type of declarations. Ask, how does the person know? What records were reviewed? Were prior servicer records boarded? Is the foundation actually stated? Finding a defect does not automatically win a case. Courts often allow banks to submit a corrected affidavit or declaration, but identifying these defects can be important when opposing a summary judgment, challenging miscibility of records, or preserving issues for appeal. Okay, guys, that does it for today's episode of Foreclosure Help 777. Again, if you are new to my channel, we do have a Facebook page that looks just like this, so you can join us. We help each other with our foreclosure stuff. And if you have subscribed, thank you for your subscription. And as always, everyone, have a blessed day.